Good afternoon, Ms. Nases. This is my video lecture in legal aspects in the hospitality and tourism industry. So last time, we started a new topic on what we call employment law, or the applicable law for employment law in our country is called the Labor Code of the Philippines. Now, why do you have to study uh, some of the provisions of the Labor Code? Well, of course, it could either be someday you may become an employee, or someday, because you're an entrepreneur, you may also become an employer. No? So, in which case, whether you are an employee or you are the employer, at least you should be able to know certain important or relevant provisions of the labor code. That way, you will be equipped on how to deal with problems relating to problems or issues that pertain to employees and employers. No? So I repeat, when we talk of employment law, we are talking about PD 442. No? This is the labor code of the Philippines. No? So labor code of the Philippines will have to deal with employment law. No? Employment law. No? So here, we need to learn, you need to study about employment law, because it's either you become an employer or an employee. So these are the two actors that you need to understand: employer and employee. Clear? So we need to study labor code because we want to know what are the applicable provisions in the employment law, and the actors or the ones that are involved will be the employer and the employee. Clear? Ms. Nases? Of course, when we talk of the employer, no? Employer, this is denominated as the employer as compared to what we call the employee. No? Of course, when we talk of the employer, it is the one who, sino itong employer? Who is the employer? The one who employs, no? Employs or engages the services or the goods, services that only goods, engages the acquisition of goods or services, no, of another, no, and this another, of course, would be what we call the employee. Okay, so I repeat, when we talk of the employer, we are talking of a person who employs or engages or acquires, rather, engages or acquires, no? Engages or acquires the rendition of services or the purchase of goods of another. And this another, of course, would now be the employee. Okay? Clear? So the two actors in employment law would be the employer and employee. Clear? And how do we know? Okay, the question is this. How do we know, or how do we determine if there is an employer-employee relationship? This is very important, Ms. Nases. No, we have to determine whether there is actually an employer or employee relationship. Why do we have to know if there is an employer-employee relationship? Well, we have to determine this relationship because we will know if that relationship exists, if this relationship between employer and employee relationship exists, then of course there are implications on the labor code, on the applicable provisions of the labor code. So how do we determine now if there exists a relationship between employer and employee? Of course, we can determine if there is a relationship between employer and employee through a fourfold test. No, there is a fourfold test. No, so in all the circumstances, these circumstances that I mentioned, 4 circumstances, they should be present, and if this test is met or satisfied, then there is what we call an employer-employee relationship. So what is the first one of this fourfold test? Well, it says that there exists an employer-employee relationship if there is the power to hire. No? Power to hire by whom? Of course, by the employer. No? If it can be shown that the one who engages, no, the services of the employee, if it can be shown that it was the employer who did it, then you met the first of the fourfold test. No? Here, fourfold. Meaning, all of these circumstances should concur or should be present. No? The second of the fourfold test would be the power to fire. No? If he has the power to hire, then the employer should also have the power to fire. Meaning, he can remove the employee. He has that power to determine if that employee is not fit to be a permanent or regular employee of the company, then he can fire him. Or if the employee was able to meet some of the just causes, no, which I will be discussing later on. If the employee commits one or any of the just causes, then the employer can also remove the employee. What is the third circumstances or requirement of the fourfold test? Well, the obligation to pay wages can also be shown. Obligation to pay wages or salaries can also be shown that it is being done by the employer. All employer. So this is the third. So who pays the wages or salaries of the employee? It is the employer. And then finally, from this fourfold test is of course the control test. What do we mean by the control test? Well, I will explain this. This is the most important and most determining, no? The control test. So what is the control test that we are talking about? Okay, this is what we mean by the control test. No? When we speak of the control test, no? Under the fourfold test, when we talk about this, meaning the employer has the power, no? Has the power to what? Has the power to direct as to the manner, direct as to the manner and or method he has the power to direct the manner and method of the work to be done. Work to be done. No? So this is the control test, meaning it is the employer who will say what or how a certain task has to be done, or what are the methods by which you could arrive at that particular work. If he has that power, say for instance, example would be, say for instance, in a manufacturing concern, for instance, or what we call this what we call the ones that are in Fugaro, how do we call that? Handicraft, no? Handicraft, for instance, for the handicraft industry, a big handicraft industry, for instance, if supposing the employer would say that the manner, no, the manner by which a certain product has to be done, and that manner he has to finish, for instance, one of the pieces of handicraft in 30 minutes, given the style of how it is done, style or the design of how it is done, then we could say that the employer has the control to direct the services of the employee. Clear so far, Ms. Nases? So, why did we say that he has the control? Well, he specifies, no, in particular, the style or the design, and of course, the time within which to finish one handicraft. No? So that is what we are talking about the control test. No? So I repeat, how do we know again if the employer has the, or how do we know if there is an employer-employee relationship? I told you there is what we call the four-fold test. And this test consists of 4 requirements. No? The first is the power to hire. No? The second is the power to fire. If he has the power to hire, engage the services of somebody, he has also the power to fire. Fire meaning to remove an employee. Then the third is the power, or what we call the obligation to pay wages. Diba? Yung babayaran yung salary, the obligation to pay wages or salaries. No? And then the fourth one, which the most important, is the control test. Control here would refer to the manner and method by which a work or a task has to be done. Okay? So this is one of the tests, the fourfold test, to say that an employer or employee relationship exists. But according to the Supreme Court, this is not all. In one case, the case is by Valeroso. No? Valeroso versus Sky Cable. No? Sky Cable. This is a Supreme Court decision. No? In one case, aside from the fourfold test, the Supreme Court mentioned also about the economic dependence test. Economic dependence test. This is also one of the tests to determine if an employee or employer-employee relationship exists. Now, what is this economic dependence test? Well, by the term alone, economic, no? And by the term dependence, who is dependent? Who is dependent with whom? The one that is dependent would be the employee. If it can be shown here, according to this case of Valeroso and Sky Cable, Valeroso versus Sky Cable, according to this case, if it can be shown that the employee is dependent to the employer, what is he dependent on? Well, about this job, no? Because a job would mean it boils down to what we call economics, no? Meaning money. if it can be shown that the employee is dependent to his or her employer because the employer holds, no, the power. He has the power to whether you can remain in your job or not. And this job, of course, entails economic returns. Definitely, this particular test is also satisfactorily complied with. So, in short, in determining whether there is an employer-employee relationship, there are two tests, no? Either one could be shown as satisfactory fulfillment. The first is what we call the fourfold test, no? Fourfold test. And the second is the economic dependence test. No? Either one, if it could be shown that this has been met or this has been met, then there is what we call an employer-employee relationship. Now, what is the significance why we have to determine whether or not there exists an employer-employee relationship? Well, I have to go back to my earlier statement that we have to determine this because there are implications, no? Implications as to the applicability. Applicability of what? Well, of the labor code. Because if it cannot be shown that there is no employer-employee relationship, then this one will not apply. But on the other hand, if it can be shown that there is employer-employee relationship, then of course it will be covered by the labor code that determines or sets forth what our employment law is all about. Huh? Employment law is all about. Huh? So in short, this is very important. No? The fact that we could show that there exists an employer-employee relationship, because this will determine whether the labor code applies or not. Huh? So we have to show first, or we have to determine first, that there exists an employer-employee relationship before we could apply the specific provisions of the labor code. Labor code again is PD 442. No, if you want to take a look at certain provisions there, PD 442 is the labor code of the Philippines. Now, we talk about employer-employee relationship. Now, here usually when we talk of the employer, we talk about the people in management. No? And when we talk about employee, of course, we are talking about the labor force. No? Anyone who is under the employ of the employer is the employee. Now, there are different types of employment, so we have to discuss that. No? Types of employment. Types of employment. So we have to discuss this now, so that we could move on to a different topic next time. Types of employment. Of course, the first one is what we call regular employment. No? Regular employment. Sometimes this regular employment, we are talking of the permanent employees in the company. Permanent employees. Now, how do you become a regular employee or permanent employee? Well, after satisfactory service of 6 months, no? 6 months. So how long are you going to serve the company before you become a regular employee or permanent employee? 6 months in the case of an employee. 6 months. That's why if you will notice, most of the companies, before a certain person becomes a regular employee, they already terminate. the contract before the 6-month period expires, no? So what most companies do, so that you do not become a regular employee or permanent employee, they will terminate your contract before the end of 6 months, so that they will not be liable for benefits, no? Because once you become a regular employee, of course you are already entitled to all the benefits accorded by law, no? So remember this period, 6 months. Now, if you have been continuously working for 6 months, that company allowed you to work for 6 months or more, then you are already considered a permanent employee. Unless, of course, the nature of your employment will be any of the following. So we also have what we call a fixed or term employment. Term, no? Meaning there is a fixed term, no? Term employment, no? What does it mean, no? If you have been engaged only for a certain period, say for instance 1 year, no? Or in the case of OFWs, because those are employment with a fixed term, 2 years for instance, no? You do not become a regular or permanent employee because the nature of your employment is for a fixed term, no? Fixed term only. So here you do not become because you have agreed to a contract which requires only what we call a fixed or term employment. So what else? Well, there are those what we call project employment. So here, for project employment, what do you mean by project employment? So these are the different types. Now, project employment, of course, you were hired or they engage your services only for the accomplishment of a certain project. Once that project has been accomplished, then your employment automatically terminates, no? Because what you have been engaged was only for the accomplishment of a certain project. Say for instance, if you have been hired as an engineer to do, say for instance, a condominium building, no? Say for instance, condominium, no? And how long will it take you to supervise the construction of this condominium? Perhaps it will only be for about 8 months, for instance. Once you have already accomplished this project, then your employment or engagement is automatically terminated. Clear so far, Ms. Nases? And then of course we also have what we call seasonal employment. No, seasonal, no? Most of the tourism occupations are seasonal, no? Say for instance, they will hire you only for a certain period, like if there is a festival, for instance, that's only good for a season, no? Or you have been engaged because there are plenty of visitors during Christmas time, then that is only applicable for a season, no? Only during Christmas. And then once the season is already finished, no, or completed, then there you go. You have no more job because you were engaged only for a particular period. Okay, next would be what we call casual employment. No, casual. What is casual employment? So you have to be very careful about this. No, casual employment. No? What is casual? You have to understand this compared to what we call a regular employment. Now, so when we discuss casual employment, you have to distinguish that with a regular employment. So casual would refer to say that kind of employment where it is not usually necessary or desirable in the employer's trade. employer's trade or industry. Meaning, if that job that you were engaged was or is not actually necessary or desirable in the employer's trade, then your employment, you have been engaged on a casual basis only. Meaning, that job or task that you are doing is not important or necessary. The word is not necessary in the usual trade or business of the employer. Then you have been hired only as a casual employee. Say for instance, example of this would be if the say for instance if the company is a supermarket, for instance, no? If the company is a supermarket and you were only asked by the supermarket to say for instance to be a promo girl, for instance, promo girl of this supermarket, promo girl, no? A promo girl is not usually necessary in a supermarket. Promo girl meaning promotional, no? It's only for promotion purposes. This one is not usually necessary or important. Even without a promo girl, a supermarket can exist, diba? This one, if you have been engaged as a promo girl, then you are engaged perhaps as a casual employee. But the problem here is if your employment as a promo girl exists after 1 year, no, you've been working as a promo girl of the supermarket for 1 year, whether continuous or not, then you become a regular employee, not a casual employee anymore. My point here is, even if your job is not usually necessary or desirable in a supermarket, but you have been engaged as a promo girl for 1 year, even if your service is not continuous, under the law, you become a regular employee. Okay? I think I have discussed so much about employment law. For now, I'd like you to take down your assignment. Okay, this is assignment number 9. No? Assignment number 9. So, number 1, Ms. Nases, this is your assignment. Number 1 is, what is the principle of security of tenure? No? First is, I'd like you to understand what is the principle called security of tenure. Okay? Number 2, letter A would be, what is a just cause? We are now talking of the causes under termination of employment. Letter A, number 2 would be, 2A would be, what is a just cause? Letter B would be, 2B would be, what is an authorized cause? No? So these are two different terms that you have to understand when you terminate the employment of your employee. No? I repeat, 2A would be, what is a just cause? 2B would be, what is an authorized cause? No? What is an authorized cause? And then number 3 would be, what are the instances or what are the circumstances or instances that fall under just cause or causes, and then what are the instances under authorized causes. Okay, that's number 3. You have to list down all the just causes and authorized causes. I think that is all for today. Good afternoon.